Hi, I'm Kareena Prescott. I'm here to discuss the legislation changes coming into force next year, which will impact end hirers, in particular within the driving sector. Okay, so if we first look at what's changing, we've got the new umbrella company legislation coming into effect. That comes in April 2026. We are also aware that HMRC are targeting tax avoidance in supply chains, in particular the driving sector. And there is a further focus on worker protection and PAYE compliance. The compliance landscape is quickly evolving. HMRC is massively targeting the agency and umbrella sector. The new legislation is hoped to regulate the sector and also to recover monies which the HMRC are losing as a result of fraudulent supply chains. Okay, so let's firstly look at the typical labour supply chains. Typically, end hirers will have an agency. An agency may outsource to an umbrella company. That umbrella company may engage a driver on an umbrella contract of employment. That agency may engage the drivers through a personal service company, known as a one-person limited company, or they may engage him on a self-employed driver basis. So in terms of the different supply models, they trigger different elements of ITPA. So a personal service company, that will fall under Chapter 10 of ITPA, which is commonly known as the Off-Payroll Working Rules, which was previously known as IR35, so whether someone is in or outside of IR35. We've then got self-employed individuals, such as self-employed drivers. The area of ITPA that triggers is Chapter 7, Section 44, which is known as the agency legislation. And we've then got umbrella employees, which are typically PAYE through an umbrella. And then we've also got agencies that may engage drivers directly themselves on a PAYE basis. So there are various ways in which the joint several liability for unpaid tax can kick in, subject to who falls where in the supply chain. Under the new umbrella legislation, there are two new definitions. So we've got the new definition of an umbrella company. So that's typically where a umbrella or a third party engages a worker on a contract of employment and subjects them to PAYE. We've then got a wider definition, which is referred to as a purported umbrella company. And within that definition, an agency can be classed as a purported umbrella company. So let's look at the various different supply chains. If you're an end client, an end hirer, and you've got an employment business or recruitment agency within the supply chain, and they outsource the driver to an umbrella company, the joint several liability sits with umbrella company and the agency. So if umbrella company doesn't pay the PAYE, both umbrella and agency are on the hook with HMRC. If you're the end hirer and you've got a recruitment agency that doesn't outsource, then potentially they will be classed as a purported umbrella company. If they engage the worker or the driver on a contract of employment, there will be joint several liability for the agency and the end client. So if agency doesn't pay the PAYE, end time you could end up picking up the tab. However, if an agency engages a worker on what's classed as a Limb B contract, which is your typical worker contract for services, then the legislation, so the new Chapter 11 will fall away and only the agency will be liable for PAYE. so the end hirer is not at risk. So in terms of you as the end hirers, what you need to be doing is understanding your supply chain. You need to speak with your agencies, understand whether or not they outsource. If they do outsource, who do they outsource to? And where that liability falls. This is in terms of umbrella employees. If your agency doesn't outsource, you need to ensure that they're on a LIMB contract for services so that the liability doesn't transfer to you. What we are aware in terms of the shift of legislation is that some agencies and or potentially umbrella companies may be driven to look at other mechanisms to pay workers, whether that's through a personal service company, through an MSC, a managed service company, or as self-employed, in hope that the new Chapter 11 falls away. The legislation is drafted in such a way that if an umbrella or agency pushes to a different vehicle and there is no commercial justification, i.e. making everybody go through a PSC, making everybody be self-employed, then the legislation under Chapter 11 is drafted that wide that it can actually capture those scenarios. So what we will look at through the rest of this presentation is PSCs, if there is a genuine PSC supply, and the risks that come with that for you, the end hirer, and we'll also look at self-employed drivers as well. So moving on to risk 1, which is the next slide, deals with the off-payroll working rules. So the off-payroll working rules, typically known as IR35, apply when a worker provides their services through their own limited company. So we'll refer to them as a PSC. If the worker would otherwise, let's not refer to them as a worker actually, let's refer to them as an individual. If the individual would otherwise be subject to PAYE, even though they're through a PSC, this engagement is going to be classed as inside IR35. Typically, under the off-payroll working rules, there are some exemptions. So the off-payroll working rules won't apply to small companies. That's provided you meet two elements of the criteria under the Companies Act. So that's your turnover is less than 10.2 million, your balance sheet is less than 5.1 million, and you engage or employ less than 50 employees. It's at only that point that you would be exempt from the off-payroll working rules. So what that means is if you, the end client, engage a PSD directly and you don't follow the principles of the off-payroll working rules, i.e. you don't undertake a status determination statement and issue that, then you're on the hook. Should HMRC find that the PSC or the individual supplied through the PSC was inside IR35, it's no longer the PSC's risk. It's your risk as the end client. If you engage with an agency and the agency supplies an individual through a PSC, then there is strict criteria that needs to be followed. You as the end hirer need to be happy that the position in which the driver is being provided for is outside IR35. In order to do that, ideally, prior to an agency advertising the role for a limited company driver or a PSC driver, you as the end client would have or should have undertaken a IR35 or an employment status test to ensure that that individual, that driver, can be supplied outside of IR35 in terms of the job role itself. That would enable the agency to advertise that position as outside IR35. Once that is done, you need to ensure that all the paperwork is in place so that the contract between agency and the PSC is compliant with IR35 and the off-payroll working rules. You need to ensure that the commercial contract, the terms of business between you and agency, supports the fact that they are supplying you with a limited company or a PSC driver. You then also need to undertake the practical element of the IR35 principles, and that's to ensure that the worker in reality, or should I say driver or individual in reality, does not look like a disguised employee. So a further test needs to be undertaken. And before that PSC or limited company can be paid, you have to have issued a status determination statement. And that needs to be issued up the supply chain. So it needs to be issued to agency and it needs to be issued to the PSC. If that is not done, the PSC is automatically caught by the legislation, which means they have to be paid PAYE. It's deemed employment, and HMRC will heavily come down on that element. There is no way around it, and there is no reasonable time frame. That is the legislation, and that's how it's drafted. What we are aware of at the minute is that HMRC's view is that drivers cannot be, in their opinion, limited company or a PSC. And the reason for that is they feel that there is a significant amount of control that is operated from the end hirer to a driver. Their argument is that a driver typically is told where to go, when to do drop-offs, and what routes to take. So it's my opinion that you need to err on the side of caution if you are going to seriously consider engaging limited company drivers. We are aware that HMRC is going to be heavily targeting this sector. And the other element is, whilst the agency, if in the supply chain, may be classed as the fee payer, so you might think, oh, well, that's okay. We're not at risk for the shortfall if HMRC find that they should have been paid inside IR35. That's not actually true. There is a provision that allows for a debt transfer to you as the end client. So if agency, for whatever reason, cannot pay that shortfall or pay the unpaid PAYE that HMRC says should have been paid, they can then come after you, the end hirer, if you have not taken reasonable care to ensure that the agency is doing what they say they're doing. The other concern that we've got within this arena is that we are also aware that there may be some agencies, there may be some umbrella companies out there that even were they being told that there is an inside IR35 assignment, that they're still operating outside. And we are seeing cases being brought by HMRC where they're challenging that, where the end client had no idea that they were being paid gross, as if they were outside IR35. Again, we can see that there is and will be a transfer of debt provision if umbrella or agency cannot pay those liabilities. In that case, it can come down to you as the end client. And again, you're going to have to be able to show to HMRC that you took reasonable care, undertook due diligence to make sure that these drivers were being paid in accordance with your decision under your state's determination statement. So if you've said that they should be paid inside IR35, you will have needed to have undertook due diligence to reassure yourself that that was being operated. If you don't do that, and they were being paid outside IR35, you could be on the hook. Okay, so moving on to risk 2 for end clients, which is self-employed drivers. This is where Chapter 7, Section 44 ITPA can kick in, which is typically known as the agency legislation. So this is where an agency and or an umbrella company down the supply chain may provide end hirers with self-employed drivers. Where we've got a self-employed person, so they're paid under their UTR, this legislation will kick in. And the purpose of this legislation, from a HMRC perspective, was to make the employment status tests much narrower. So this particular test under Section 44 purely looks at whether the self-employed individual is subject to the supervision, direction and/or control of the end hirer and/or the agency. HMRC's view and guidance typically states that they feel drivers in particular would be caught by supervision, direction and control, which then means that Section 44 kicks in, so they should be subject to PAYE. And the reason for that is, with that test being so narrow, is they feel that most drivers will be somehow supervised, directed and/or controlled by an end hirer. So again, if we was to look at a Amazon driver, for example, like they may say, right, well, we've got 100 packages here. These packages need to be delivered within these timeframes, and these are the routes that you need to take in order for it to be fuel effective. HMRC's view is, well, that is then being subject to supervision, direction and control, which means PAYE should be applied. It is such a narrow test. It's not as wide as the off-payroll working rule test. On that basis, what that means is that typically agency, so even if there is an umbrella company in the supply chain, it will still be the agency's risk if they supply that self-employed driver and pay them gross pay. And HMRC go, oh, hang on, they were caught by Section 44, you should have paid PAYE. The issue we've got for the end hirer in this scenario is that, again, if agency cannot afford to pay that PAYE liability, because it could be that we're not just talking one worker, it could be that they're supplying 100 drivers, then that liability is obviously significant. If they cannot pay that, then we've still got the debt transfer provision that HMRC could kick in. So again, that's going to come down to reasonable curve from the end client. Did they ensure the agency and/or the umbrella in the supply chain was subjecting the drivers to PAYE? If they weren't, were the correct tests being undertaken? So were the supervision, direction and control tests being carried out with each individual driver before they were being supplied? Did the contractual documentation throughout the supply chain support that supervision, direction and control didn't apply? If not, then typically those drivers are going to get caught, and you as the end hirer, as well as the agency, could potentially be on the hook if agency can't pay that PAYE liability and you've not taken reasonable care and/or due diligence up the supply chain. Okay, so risk 3, or potential risk for end hirer, is within the umbrella supply chain. We have briefly obviously discussed what the new legislation changes mean and how they can impact. But what I wanted to cover here more so is some sort of live examples of matters that I'm dealing now with for recruitment agencies that involve HMRC investigations. So what we're going to cover here is risk of non-compliant umbrella companies, liability transfer and reputational risk, what end clients should do in terms of due diligence, how they should verify PAYE, and ensure contractual transparency. So if we have got a agency that is utilising a umbrella company, I've got to stress they can be a compliant umbrella company or they could be a non-compliant umbrella company in terms of their operation. If for whatever reason that umbrella company does not pay its PAYE, and that could be whether it's just withholding PAYE from HMRC because they want to run off with it, or if it's because actually they've got into genuine financial difficulties, and PAYE in those instances tends to be the last thing that gets paid, then that risk will transfer to agency. In that scenario, you've obviously also got the concern that that could negatively impact your supplier, i.e. your agency supplier, and they could fundamentally, if they can't pick up the tab because they've already paid over the PAYE, so they're getting hit again by HMRC, then you could potentially lose your supplier. What does that mean for that workforce? Could they lose out on getting paid? There are a number of risks from a reputational perspective that can sit with that, even where you may think, oh, it's okay, agency's using an umbrella company, so actually my risk is limited. There are other risks associated, risks that your drivers don't get paid, and also reputational risks. We are aware, well, I'm aware, I actually had a 3-hour HMRC meeting this week with a senior HMRC officer and my client, where they highlighted concerns in terms of the supplier, the umbrella supplier that my agency client was utilising. We obviously weren't privy to some of the intel that HMRC had, but they were sharing the intel with us at that point. My client has done due diligence, and I mean extensive due diligence on their supply, which did give us reassurances that they were operating legitimately, paying PAYE and paying VAT. However, it transpired that that wasn't quite the case, because obviously we don't get to see the HMRC systems. What HMRC did say in that instance was, if you don't look to move away from using this particular supplier, we will raise an assessment. That can be that was a potential VAT assessment and a Reg 80 assessment in terms of PAYE liability. Then we're going to write to your end clients. And the reason that obviously HMRC are aware of who the end clients are is because they've got the statutory right to see invoices between agency and their clients. So that lists you as the end hires. You are on HMRC's radar. And they were going to write to those clients to say, do you know your agency is using this supplier and we don't feel that they're compliant. We feel that there's fraudulent activity going on with the supply chain. So not only is that within HMRC's power, it's also putting you on the hook in terms of you're within a fraudulent supply chain. The other thing that we have also recently become aware of is HMRC is now going to end hirers where they've got concerns with umbrellas being utilised within the supply chain. And they say to those clients, what reasonable care have you undertaken to make sure that the supply chain that you're utilising is legitimate and is compliant? So they're then getting you to do disclosures to them as well. So not only so you can't just say, oh, it's okay, I don't need to worry about this, because this draft legislation as it's currently written doesn't put us on the hook if there is an umbrella at the top of the chain in between the us and the agency. You are still at risk. If you are utilising an umbrella directly, you are on the hook for JSL, regardless. So reputationally and just being on HMRC's radar, you are at risk still. You need to satisfy yourself that your agency and or their supplier is paying PAYE, that you can see that the RTI submissions have been submitted. And also, I would be asking my agency clients or my agency suppliers to give us evidence, real-time evidence that they have seen the government gateway, showing that PAYE liabilities have been paid. And also the same for VAT, because we are aware that, unfortunately, within the umbrella sector, there is a lot of that fraud that's happening. And this will be able you to show HMRC that you have looked at the supply chain, you fully understand the supply chain that's in place, and that everything is transparent from top supplier down to you as the end hirer. I guess fundamentally the safest way for you as an end hirer to work is that purely with an agency that's engaging workers directly on a Limb B contract and supplying them to you, because that means you are not at risk on the JSL front. But what I would still recommend that you do is that your agency still do compliance and due diligence with you so that they can show that they're paying the PAYE, RTI submissions are being filed, and that gives you a level of security and peace of mind should HMRC say, well, what have you done to ensure that the supply chain is legitimate? So in terms of the umbrella supply and risks associated, one other important factor is that from the 6th of April 2026, there is going to be no statutory excuse in terms of your reliance on a defence that, well, we must have been given a fraudulent document. That is no longer going to be a defence, regardless of what due diligence you've done and what paperwork you may have in front of you that says, oh, that PAYE liability has been paid, etc. If HMRC's systems are showing that it hasn't, you're still on the hook. So again, that's why I would be asking for live videos and Teams meetings at the gateway so that you can actually see it in real time. Right, so just a quick overview of the typical supply chain flow charts. Your first one could be your PSC driver. So you would have an individual, a PSC, that would be engaged by the agency and then supplied to the hirer. In those instances, a status determination statement is required to be issued from you and hirer up the supply chain. Otherwise, you could fall foul of the off-payroll working rules and PAYE liability could kick in. As we've mentioned, if there is an agency in that supply chain, them's the fee payer, HMRC will go to them first. However, if they can't pay that liability, there is a risk that there is a transfer debt to you as the end hirer if reasonable care hasn't been undertaken to ensure that the correct pay method has been undertaken. The next typical supply chain is umbrella employee. Engaged by umbrella company, supplied to agency, supplied to end hirer. The JSL sits with umbrella and agency to verify PAYE. If there is a shortfall or if PAYE hasn't been paid, that sits with umbrella and agency. However, you as end hirer have a risk that if that's the case and that umbrella or agency go bump as a result of that liability, workers may not get paid. You will have paid that money over for the workers to be paid. You can be out of pocket and you've got huge reputational risk that can sit with you as a direct result of that. You've then got the next supply chain flow, which is self-employed drivers under Chapter 7, Section 44. So you will have the driver to the agency to the end hirer. You need to undertake supervision, direction and control checks. If any provision of supervision, direction and or control applies, PAYE applies and Section 44 kicks in. That risk is with the agency. However, if agency can't pay that liability, again, if you can't show that reasonable care has been taken on your part to ensure that those checks have been undertaken and that the correct pay method has been applied, then you could have to pick up the tab under the provision of debt transfer that HMRC can kick in. There is one other flow that I haven't put on there, which is worker to agency on limb to end hirer. JSL does not kick in. It does not sit with you as the end hirer in that instance. But again, we would still recommend you do your due diligence, carry out checks. But that liability would purely sit with the agency. So I guess fundamentally, if you want to be risk adverse, the fourth option in terms of supply chain is the safest option. Okay, so what steps should you take as the end hirer if you're utilizing an agency? You should conduct in-house due diligence, ensure that you are aware if your agency is outsourcing to an intermediary, i.e. an umbrella company, and that you're confident that umbrella company is compliant. What I will say is that the Chapter 11 legislation means that the most compliant umbrella company can still get into financial difficulty and there can still be a PAYE liability risk under the joint several liability provisions contained within. However, if there is an agency within the supply chain, it will sit with agency and umbrella. But there's a reputational risk. If you, the end hirer, engage in direct with an umbrella company, that is the umbrella company and your risk in terms of JSL. Again, if you're using PSCs or self-employed drivers, again, that due diligence and ensuring the correct mechanisms and processes are in place are vital if you don't want a debt provision transfer to you. You need to ensure that your agencies are being transparent with you, telling you if suppliers, intermediaries involved, and make sure that the contractual documents in place are sufficient. Ensure that there are strong indemnities and warranties within your terms of business between you and your agency suppliers. Well, you do have PSCs. You should be utilising the HMRC tools such as the CES tools or getting independent tax or legal advice. You can't just assume that your agencies are getting it right because you could be on the hook. So what should you do? You should maintain supervision, direction and control checks. You should keep them on file. You should make sure that you're undertaking statement determination statements where you've got PSCs. However, we are aware that HMRC don't believe, in their opinion, that drivers are genuinely self-employed or that they can operate as PSCs. So if you have any concerns or questions that have arisen out of this presentation, please don't hesitate to contact me. All my contact details are available on the front of the slides, and we'll be happy to assist in any queries you may have. Thank you.